distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey, hello. Whew. Damn, today was interesting. Today, well, we had some Mr. Brennan started off with the final questions, and then it was a race to who is the most it was a battle between an exceptional attorney and an expert who has been up against a very, very large amount of excellent attorneys regarding civil cases. And both seem to have roughly the same, well, not the same tactics, because Alessi wants to get Welcher into a certain point where he can impeach. Welcher has made everything so vague about his report, everything but his conclusion. Everything about his report is knowingly vague to give himself out. And so today was Alessi trying to get into specifics and Welcher trying to, oh, I don't understand. So I'm having a beer for this one. I'm having a day off tomorrow because it is Ascension Day tomorrow. So we are free. We have it's a state mandated day off tomorrow for Ascension Day, which I think is very, very sweet and very, very interesting, because Sweden is one of very few countries that actually has this day off, which is a bit strange considering that Sweden is supposedly one of the most non-religious countries in the world, while super religious countries don't have a day off for Christ Ascension Day. I find this very, very strange, but that's kind of beside the point. But I'm having a day off. I'm having a beer. Wheel of Regrets is in play, and we have a lot to go through, and it's annoying and it's unnerving, but I will try my best to not get demonetized. But I will try my best to answer any questions you have, and I will try to translate what is going on in my opinion. So I don't know where this will take us. And also, hello over at Rumble. Good to have you here. Good to have you here. Hello, both Nick Starro channel and Trial Watch Clips channel. Hello to you guys. Because if you don't know, the Trial Clips channel, it is my secondary channel where I usually post fun clips of George Simpson, George Boyd, and stuff like that. I haven't had the exact time, much time to do this at the moment because of this. So I chose to do this stream at that channel too, to get a few more subscribers and a few hours in, because that channel is still not monetized. So if you wouldn't mind, you on my main channel, to pop over there and say hello, press the thumbs up, and subscribe if you haven't done so yet. And then come back here, because I need the numbers here as well. All right, folks. Let's go through it. Let's go through it. This will be interesting.
All right. Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded.
Oh, yeah. Almost forgot about. Yesterday, Dr. Welcher made a legal conclusion. Alessi and Brennan, opposite sides, of course. And here is Judge Bev's decision. If Dr. Welcher actually can go as far as he did yesterday in his conclusions.
And analyzed, and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However,
that's not entirely true. Before, they had a whole lot of discussions regarding Dr. Welcher, both pre-trial and in the middle of the trial, since he seems to have, he changed his report. So I don't think it's accurate that it was done without objection.
However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe, because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right, so the jurors...
So she went on Alessi's line. Mr. Welcher cannot say conclusionary that Karen Reed's Lexus hit John O'Keefe. He can't. He can say it's consistent with, but he cannot conclusory say what, because it was stricken yesterday. And so how about that? Judge Bev making a correct ruling.
Lining up, we should have them momentarily.
Thank you for the late coffee.
Okay. Is Dr. Welcher right around?
Yes.
Why don't we bring him in if he's here before the jurors? Agreement with this, Mr. Alessi?
I haven't gone through it, but I have no reason to believe that I wouldn't be in agreement
Okay.
Yeah. So now,
There is one slide, so I'll admit it conditional to redactions that.
now
Jim
Dr.
Blue
Welcher
on
had to
was
remove a bunch of stuff from his slides because, as it seems,
Do you know
what
do you know the
Brennan
number?
promised
You don't have to find it if you
didn't
don't.
happen.
131.
Oh, is this was it 130? Was it 131 yesterday too?
It was.
So at sidebar, I said we could go back to that, and Mr. Alessi agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to 132. That was my understanding at sidebar.
Can this get any worse? Oh, you sweet summer child.
Okay, so look at it again. That's not my understanding, Mr. Alessi. It was you were concerned just about the heading, and then I said we'd go back to both slides.
That is one of the points I made yesterday. What Dr. Welcher had on the header of his slides should never be there, because there it said evidence that Karen's Lexus hit John O'Keefe. That in itself, if it was objected to and litigated on, and he still chose to show it, in my opinion, that should throw him out, because he knowingly violated I don't think this was a court order, but the agreement between the parties, which Judge Bev agreed to.
Oh, yeah, no, I'm okay with that.
Yeah.
That one, yes, your honor's recollection is.
Yeah,
correct.
and-
Go ahead, you move.
And we were going to start on that, but you thought because I struck it based on the objection, but then at sidebar, I said we could go back to that. That's your understanding too.
Correct, Your Honor. Yeah, you sure that Dr. Welch took off the heading on 131?
I think he did, but because I think he took off from 124 to 1.
I did.
Thank you very much.
Okay.
I would like the prediction.
Cheers, Euro 13.
Are they out there, Paul? Okay, thank you.
Your Honor.
Good morning, jurors.
Yeah, I don't need that.
Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asked.
Just one thing here. For the past 5 weeks, we have seen Mr. Brennan with his bald spot. Where did that go, Mr. Brennan? You had it a few days ago, and now you don't. Did you make an appointment with the hairdresser and got spray on hair, Mr. Brennan? Did you get spray on hair, Mr. Brennan?
Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do,
There
I'm gonna
might
ask
be
you
snark in
two other
my
questions.
streams.
The first is
You've been
I asked you
warned.
to
You've been warned.
turn to your PowerPoint, slide 110.
You want me to display it?
Please.
Oh, I saw. Now, the bald spot is covered because to punish Mr. Burgess, he shaved off the tuft and put it on his head.
I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 114, 115.
how many times did you engage in testing where your arm and forearm touched the rear right of the exemplar
This is
Alessi?
so stupid.
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
Oh, this is so
If you could
stupid.
turn to slide 130, please. What? Could you go back one, please? Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is.
Oh, could you take that down, Dr. Welcher?
Thank you, Mr. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you,
So we need to take this.
Sorry,
you take the PowerPoint down, please.
that was in a different spot on the slide. Hold on a second.
Hi, Divans.
That's fine.
Thank you. Sir, I had asked you yesterday about some of your opinions. I want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight.
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle.
The physical evidence at the scene. Which ones? The one that was found on the 29th, the 3rd, the 8th, the 11th, or the 18th? Which ones?
To a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and look.
Excuse me, Your Honor, pardon my interruption. I just want to know if you read from something or not read.
Looks like he's counting on his fingers. Are you reading from something?
No, I am counting on my finger.
Okay, thank you.
So I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I need the same type of shoes.
You are such a creep for playing dress up as John O'Keefe. That is so creepy and had no scientific value whatsoever. It's pure creepiness. And it is to paint a picture for the jury so they can watch John O'Keefe getting hit by a Lexus. That's it. It's pure theater with absolutely zero scientific value. And it's creepy and it's disgusting.
My exemplar inspection, where I matched up the heights, the locations of the lacerations, and then the text stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm.
Is that the only two theories you've seen? Are you really sure that are the two only theories?
If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether, based on the data and based on the physical
Did
damage
you
and
test
your testing,
that,
whether that is consistent with a collision
Mr. Welcher?
or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And is that
That is the first time he has ever mentioned frozen ground. Did you make any tests with a crash test dummy? Oh, we saw that test, didn't we? Did you use frozen ground, or did you use a concrete floor? Oh, what's that, Mr. Welcher? You used a concrete floor, not frozen ground. So how the fuck can you decide that these injuries would happen on frozen ground? You can't, because you never tested it. Oh, this stream is going to take a while.
Specifically pertain to January 29, 2022, around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
Yes. One of the original theories from the state, original ones, was fight in the car. John got out, threw the cocktail glass at the car, and Karen backed over him. Yeah, that was actually one of the first theories in this case.
To finish, I'd like to ask you a few more questions. You've written some papers on sideswipe collisions or clipping. Can you describe for the jury and explain what a sideswipe collision is, or a clipping, and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is...
Isn't it a clear difference between side swipe and clipped? Side swipe for me is a person not actually hitting a part of a car, but it's more or less being grazed. Yeah, you've seen stuff like that. People on a crosswalk who walks, but they manage to get out of the way, but they are still sideswiped by the car. That is what I call clipped. Means there was a collision of sorts with parts of the car. That's just me.
What refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit, and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car, and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contact, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars, because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult.
You have, in your report, you claim to have the speed. We will get into that a bunch of times during his testimony, but I will submit to you guys that what he claims he doesn't have is actually in his report.
Difficult to determine,
and that happens
even when you
a lot.
have an area of impact, which is where the person was when they got hit, and a point of rest where they've landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts, and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion.
They talk. I'm already at 1.25 speed, and they are. I think we can get by 1.5. Let me know if you think
the
this
person.
is going too fast.
So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper, as opposed to side swipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the...
In this trial, you have claimed that the Lexus wing hit John's eye, that the arm was hit by the taillight, that his hip made contact with parts of the car, and his knee had impact with the car. This is no longer a side swipe. This is barely a, I mean, if all those parts of John's body actually was struck by the car, that means the entire side of his body was clipped by that car without causing any bruises or any bones to break. Isn't that correct, Mr. Welcher?
Literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures, depending on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it's not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
Sorry. I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top. This was an instance where we had, this is an image from the police report. No. Let me see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops. On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, the buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you
Thrown.
expand that? I'm sorry.
Yes, yes,
Please,
sure.
do you want that expanded like 2 times?
There you go.
Thank you. I'm sorry to.
Yeah, no, my pleasure. Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures.
That is a lie. What he just said there is a lie. And we will get into that at some point in the cross-examination, because he is referring to a 1979 study. How many SUVs existed in 1979? What safety features existed in 1979 and what exists today? The most common injuries in today's world is not head injuries, it's lower body injuries. Let's listen to that.
Had a severe brain injury, which again is the most common injury in pedestrian crashes.
Severe brain injury, which is the most common injury in pedestrian crashes. It's not. Folks, why would he take a 1979 report to make this point when there are literally thousands of reports from, say, 2010 up until today that says it isn't? Why would he make that as a fact? Why would it say that as a fact to the jury? Well, he had to go back to 1979 to find a study that supported this claim. He had to go back almost 50 fucking years to find a report that backed this claim up.
He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand.
That was from the CPR machine.
Extremity wound with vascular injury. So no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at
Oh, let's see here. Oh, is he already at this point? Let's see here. I have to. Did I miss that? Hold on. Yeah. Okay. I was busy talking. This is the example he's making. Let's see if we can find just this one. This is his example of another dead person. Look at all the trauma that he is using as example here. Right subdural hematoma, multiple abrasion on his right knee, left anterior leg, lower back, right lower back, left buttocks, and so on. If this is the example, this is probably the only example he found of a clipped or sideswiped person who died with a head injury. The only example. And this guy has so many injuries, it's stupid. And also, the point of impact, left tissue, left blood. You know what's completely absent from any point of impact the state alleges on the Lexus? You know what's missing? Tissue. The state claims that it caused the lacerations on John's arm, but left no tissue. or blood? What is the odds of that?
The lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
Hold on, what did you say there?
So when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
A number of abrasions.
Thank you. You can take that down, please. Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body breaks to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a side swipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your Honor,
pleasure.
I would move the evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
Thank you, Your Honor. Thank you.
And finally, it is time for cross-examination. This, not surprisingly, will take the rest of the day.
In both the flash drive and the no.
I don't think so. I don't think it was mentioned. Let's see here. No, it's well, here, impact speed of Ford 25 to 35 miles per hour, so upwards of 35 miles per hour. It left tissue and blood on the impact. What's interesting here is if there are no injuries to the lower part, what actually hit that part of the car? Because that is all these things, all the buckles and stuff, all the dents, all the scratchings, all of that is on the lower. What this makes me believe that this, what is presented here, is either a bicycle crash or a runner who somehow made it that his head or parts of his torso got to that. Because as you see here, this doesn't make sense. It's just and upwards of 35 miles an hour. I don't think this is a good example, but who am I to know? No, that was not what I was after.
It's for the wall.
Your whole name?
Robert Alessi, sir.
Robert Alessi. Nice to meet you. Yes, you could definitely have this type of impact and not.
Now, what is going to happen here? This
In both
is how I know that Mr. Welcher, he is a seasoned expert, especially in civil litigation. He must have been in hundreds of cases, if not more. He must have been deposed vast number of times because he tries to throw Alessi off. The first thing he does
flash
is
drive and the notebook. Let's put them both together.
and this is how we do it.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Alessi. Nice to meet you.
Nice to meet you.
Have you ever heard this coming from? This is also how I suspect that Welcher has seen this trial. because this is Mr. Alessi's line. He says this to every witness he cross-examined when he hasn't been formally introduced. So why on earth would Welcher know to use that exact line? Yeah, I know it's speculation from
Dr.
my
Welcher,
part, but
the area in which you engage can also include, and I believe you use the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay,
Yeah.
yeah, certainly for the court of law.
It
Yes.
ends up to a court of law, and in forensics is a common term.
Yes, sir.
So it relates to or it's used in or it's suitable for a court of law, the analysis.
also this interaction here, we will see similar to this a lot, where Alessi asked a question, everybody involved knows what he's asking, but Mr. Welcher has to turn it to you're not correct. This is the correct one, and he does that a lot. And here's one of my: how does the jury see this? Because at every point that Mr. Welcher doesn't want to answer, he pretends he doesn't understand the question and tries to turn it around that it's your fault. Well, he doesn't say that, but he tries to turn it on Mr. Alessi, that your questions are weird. Well, this is not verbatim, but this is what Welcher tries to do. He tries to turn the jury away from his inability to put out a straight answer into, no, it's not me. It's Alessi's fault. He's strange. He doesn't ask the correct questions. You will see this a whole damn lot during this cross-examination.
You agree with that's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information, truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes, the reasonable degree of scientific certainty?
I might have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. No, I do my best. I believe I've done it here.
Okay. So in terms of you've agreed that you apply the scientific method. So I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National
Yes,
Yeah, so would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
so for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence. So frequently there's one or two versions and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science, 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm sorry,
So
should
to
I
get
interrupt
peer,
you?
I need to,
Go ahead and answer your question.
you're asked peer review, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you used here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
I believe Gwendolyn is correct here. This means understanding the questions
The
on
scientific method
purpose.
that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you,
So hold on a second.
Okay,
Generally, what
okay.
you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question. So I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or text stream data do we have?
Here, I do believe Alessi was a bit too vague. Sometimes Alessi uses vagueness to then pin them in on a specific. Here, I think he went a bit too vague, because I think he meant something else. And I think, if I remember correctly, we will get into it.
What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you, at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen until the end? How do you then not get your hypotheses up front when under the scientific method, you should be having different hypotheses up front? How is it that you ask how did it happen at the end and not go through hypotheses at the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like, for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking.
It is so hard for Alessi to pin Mr. Welcher down to specifics. And I do believe this is because Mr. Welcher has had decades of civil litigation. And if you watch the Take Care of Maya trial, you know how exceptionally vile some attorneys and experts can be in a deposition. And this is a guy who primarily, in my opinion, have worked with insurance companies to deny people coverage. And hello, folks from Catnot Williams. Hello. Good to see you. We are recapping the Karen Reed trial of today. This is cross-examination of the state's final witness, Dr. Welcher, who is their crash reconstructionist, who refuses to answer really easy questions. Good to have you here, folks. Good to have you here. Hope you stick by and listen to this. And of course, this is a commentary channel. I will pause and speak my mind. There will be curses. There will be bad words. And in this case, because I know what a cluster F this is. I'm having beer because I'm having tomorrow off. And also, if you're new here, hey, good to see you. Hit the like button, hit the subscribe button, and then when you have time for it, check the link in the top of the chat. That is my Trial Watch Clips channel, where I usually throw up videos and clips and shorts of Judge Boyd, Judge Simpson, stuff like that. But primarily, this is my main channel, and I am probably going to curse a lot today.
Asking about the hypotheses, sir, you would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down.
That was the exact question Alessi asked of you 10 minutes ago. And all of a sudden, with moving around, not answering, now you say the exact, now you're actually answering his question, almost repeating it back to him.
The number of questions.
Maybe I can just this last question to make it clear for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses. You would agree that even though hypotheses can be created and changed perhaps all the way up to the end, you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
Oh yeah, they're going to get into this, how much Aperture actually got paid so far. And let's just say my estimation yesterday of close to, if not over $500,000 to Aperture alone, I wasn't far off. I was not far off.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this. Isn't it the case that when you have multiple hypotheses, the one that most, out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate.
Okay,
But there's exceptions.
fair enough. But as a general principle,
Sure.
with some exceptions, that's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Okay.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts State Trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well, I'm
know,
familiar with his reports. I don't know the man.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is it the date, January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple of days. Okay.
Right.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right,
I would
so-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
No, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Oh, folks, this is the executive vice president of Aperture. Now, do they have a billing department? Of course they have. But is this guy trying to tell me that he has no clue about what work is being done, what work he is involved with, what the billings are?
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that.
So
We're
you
an
would,
engineering company. We bill for our time.
so you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly. So you've been on this for 2.5 years. So if it would
And they hear Mr. Alessi misspeaks. It's unfortunate, happens.
take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just
Okay.
go right to the bill. You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign. So I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the
Oh,
Commonwealth.
I
I
have
signed it.
something
you
interesting
signed
to show
And
you.
wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work and the Commonwealth pays for it, correct?
First of all, it's really funny that the defense is putting this on the state's expert. In almost every other case, this is what the state does to a defense witness.
Right?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we pay for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The
if-
obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is
Yeah, folks. 325,000 plus 44,000 and change is 369,000. And this, folks, was in April. Since April, they have made 2 supplementary reports. Burgess did one. This guy did one, where he changed stuff. They are billing for that time and everything. Then you had, what was it? 3 days of Burgess on the stand at $450 an hour. And he's probably getting paid for full days, plus room, plus board. Now this guy is here, who is, by all accounts, much more expensive, because he has an actual degree. So I would estimate Mr. Welcher at $700 to $800 an hour. And this is day 2. He will stay here until day 3. And remember, folks, I believe Mr. Welcher is also a rebuttal witness. You can easily add on, since April up until now and for the rest of the trial, you can easily add on $100,000 plus to the 369,000. So we are up at almost $500,000 for something the state has in-house. $500,000. I'm not done yet. Oh, wait. There's more. Let me bring you up and introduce you to Barry Lewis. Who says, Dr. Welcher has testified Aperture LLC has been paid by the Commonwealth with a maximum obligation as a part of its contracts with the Norfolk County District Attorney's Office. The Norfolk County District Attorney's Office has failed to disclose those payments to the state auditor and its CTHRU system. According to that system, not a single penny has been paid by the Norfolk County District Attorney's Office to Aperture, and he has the receipts. So why haven't Aperture been paid yet? Are they waiting for the result of this trial? Are they holding in payments? Because the 44,000 should already have been paid. That was to retain them. Why is there no trace of this money? I would say it needs to be looked into. This is not normal. Now, this $325,000, this is the obligation. Yeah, a company like Aperture can technically, they can live without that money for up to a year, as he said. But not a single penny, not even the $44,000 retainment, not even that has been paid. Or it has not been, as he says, it's not disclosed in any paperwork. Here's my speculation. every case gets a budget. All cases gets a budget. What if there is no approval for these extra expenditures? Because the DA's office, even though it's an entity in itself, has to answer to Norfolk County. Has Norfolk County approved? That they did approve of in excess of $250,000 to the prosecutor Brennan as a special prosecutor. But did they actually authorize a combined $750,000 expense on one prosecutor and 2 witnesses that they have in-house? Maybe they did. And if so, they should answer to it by the citizens of Norfolk County, that this is what their taxes are paying for. All right, let's get back to the trial.
Obligated to pay at least $325,000. And is that correct?
That is
Yes, for always, forever, for life. In Massachusetts, they have an entire department to use for crash reconstruction. That was Trooper Paul. And Trooper Paul not only is a member of that unit, he trains new crash reconstructionists in that unit. All of it in-house.
is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates, you said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office.
3 entire offices is working on this case alone. The state of Massachusetts hired Aperture, who has this said to 3 offices, including the one with the executive vice president of Aperture. This is the case you should work on.
Office. There's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
Madam Welcher.
Yes.
Madam Welcher.
Yes.
Sir, yes.
Yeah, could you direct me so we're not wasting time?
Well, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you. Your Honor.
And then when he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor. Thank you.
Thank you, Ghosts. Yeah, this channel does not give financial or general advice that should be relied upon. Always consult professional, as your circumstances will be specific to your situation.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So It was like $325,000.
The executive vice president of Aperture signs contracts without reading them. Yeah, sure.
I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach your honor?
Okay.
And Dr. Welcher, I'm now going to, you asked me last time, hope this is helpful. You said please point to the applicable part so we can do it faster. I'm now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Yeah, I'm not saying it's going to happen, but if you publicly state that you don't read contracts, you just sign them, there might be a lot of contracts heading your way, but with the money going in the opposite direction.
And we got started on this conversation, tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
You submitted an updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this.
Mhm.
The updated presentation, we'll get to the changes later, but the updated
This is going to piss you off what's going to happen right now.
presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Yesterday, at the short voir dire, he knew exactly to the date when this report, when this slide, all of that happened. He knew to the date and he could answer it in the voir dire immediately. And today, memory loss.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Liar. You know exactly when you turned this in because it was after Burgess May 8th. You waited then a few days and all of a sudden, boom, you had made alterations in your slide.
Do you know when?
Hold on one second. Dr. Welcher, I'd ask that you not do.
Not looking. Okay, I was going to try and answer his question. My apologies. I will shut it down.
This is interesting. Judge Bev is getting annoyed at this at Mr. Welcher because he keeps looking at his report, even though he was told before cross-examination to put it away. You can watch it if the question demands it. And that is not up to you, Mr. Welcher, and you know this, but you keep doing it.
Thank you. You're welcome. If I may, Your Honor, please
Yes.
stay here. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting
Your
to do.
Honor, may he do that?
Yes, I'm going to see Councilor Taiba while you pull that up,
Thank you.
please.
Skipping.
Question. Dr. Welcher, what I'm going to ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So,
Your Honor, yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes.
Yeah,
When
Welcher had
did
his
you
laptop
create
open
the
a
updated
lot
presentation
during
that you
cross-examination.
Reviewed in your direct testimony.
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question, it's this. the version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
He makes altercations every day, apparently. But here's the thing. Everybody involved knows what this question is about, and it is the substantial change he made and submitted on May 13. But he's trying to make it look like, oh, Mr. Alessi, you're not specific enough.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question. My question is, how many times have you changed it within the last 2 weeks, your presentation?
Try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your
Didn't he say just a few minutes ago that he had no idea when he did that altercation, and all of a sudden, boom, May 13.
PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer, so I didn't.
No, I'm not sure how much granularity you want to that answer.
Right. So you created on January 30th, 2025. You made your
13th.
Pardon me.
Oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right. If I could finish my question, I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths.
Oh, no, you didn't. That was after, I believe.
To where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
Right. So
That was the second half.
yeah, I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this. And
Please.
if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Ms. Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right. So that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
Because I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
And he plays it off at, oh, this is nothing. Well, if it's nothing, why did you make the change? If it's nothing, why did you make the change?
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony.
So A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So
First of all, it's middle of the trial. You should have been done. Now, if you get a hold of additional evidence, you take it up with the court. I need to make changes because I have new data. That never happened. Second of all, for fuck's sake, Karen Reed should never have done any interviews. None. I don't know why. I don't care why. All I know is that you provided them with information they didn't have, because you either thought you could say it, somebody told you you could say it, or you didn't care what you said. But ultimately, it boils down to everything you say can and will be used against you in a court of law. And all those interviews, all those clips, if Karen Reed is found guilty of anything in this trial, it's because of those interviews, in my opinion.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welcher, I have to ask you
Oh,
not to
sorry.
refer to
I'm
that.
trying to be helpful.
Close your
Yeah,
computer.
let me close it. Sorry. I was trying to answer his question.
And he does it again. Just 5 minutes ago, he was told, gather the information you need and then close it down. He closed it down, and then, without asking, he popped it open again. He does this all the time. It's unnerving. He should be reprimanded, and eventually he should have no access to his report and go only by memory.
So I'm going to ask you to close the.
Yeah, that's probably a good idea.
Just let- Thank you.
Thank you, Your Honor. So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brennan.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
A reminder here, the state, when this is the second trial, and the state in the first trial said, we are ready, we can convict Karen Reed on the facts we have. And almost everything that they had in the first days of that trial has now been debunked. The time it happened. everything revolves around the time this happened. And their initial theory presented in court by Prosecutor Lally was Karen Reed hit John O'Keefe at 12:45 a.m. We now know that was completely false. They had gone through 2 grand juries, and the first couple of days, ow, for fuck's sake. Mr. Jingles, if you don't boop with claws, don't boop with claws. It hurts like hell. Where was I? Yeah. Sorry, folks. Where was I before I was assaulted? Yeah, the first days of the first trial, everything changed in the state's theory. And it keeps changing all the damn time. Even mid-trial, second trial, they changed the time.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
Weren't you sequestered to not find out? And here you are saying you had a discussion with Burgess? It's so corrupt.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that should be looked at. What's the basis of your understanding that he found new information? Okay.
I'm going to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting in our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what he said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether in fact it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data, whether it's new, old. Oh, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, have you ever? has Aperture
That's
ever
actually a
submitted
good answer.
A changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you say,
Yeah, when asked to do it. Nobody from the court asked you.
here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer? Oh, speak for yourself. So can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
This, and he never thought that would be an issue. To mid-trial waving your hand, hey, change my mind over here. After the defense had locked down their entire defense. All of a sudden, here you are, here budgets are, and saying, yeah, we changed our mind. And that's not significant. Twat.
You're welcome.
Mr. Alessi, is this a good time for a break or
It-
5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our morning recess again? Dr. Welcher,
Great. Love to use the rest.
All right.
Be ready, Mr. Alessi.
Thank you, Your Honor. And if I
All right. Let's see if I missed any questions, just write them again. If you can put in one of these big red question marks, it makes it easier. And of course, there are other ways to really make sure I see it, but that's not. A super chat is never required on this channel. Never. I appreciate it if it happens, but I will never. Unless I'm doing one of my grifting streams, which happens maybe once a month or once every second month, when I purposefully do stuff for money, I will not ask for money in my regular streams. I don't mind it, but it's not necessary. Let's see here. Dun, dun, dun. Dun, dun, dun. Bev needs to open a drinking establishment. Name Sidebar. Yeah. Diana, what for the data was wrong? The problem here isn't if the data is right or wrong. It is, did they collect it from the was the analysis of the data correct? Do they actually have that 3-point turn correct? Do they actually have the 1162.2? Is that actually the data point they are looking for? Because if that is not correct, which it isn't, in my opinion, then they can just add on time slots and time management and drifting times, which they have, in order to make it fit with the state's case. And that is, in my opinion, insanely corrupt.
please address an administrative matter that I wish I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
It was
Closed. Yes.
Did he open?
So it's just, did you just turn it on?
No, but I will. I close it. You like want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm going to see counsel at sidebar,
Sure.
please.
Yeah. So during this pause, apparently, Dr. Welcher chose to, hey, let's open up my computer again and read through the things I think the defense will ask me about. He's been told over and over and over again, do not look on the damn thing unless the question demands it, and then you ask for it.
Lunch break, I'll ask you to remove those monitors.
Mr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes. Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up, and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going on. I mean, there's been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
So you were contacted by the prosecution regarding this new thing that Burgess found?
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications, what this trial is going on, relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
Going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is event data recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, event data recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data
That, by the way, last week I covered Trooper Paul's testimony. And this is one of the questions he had such hard time answering, simply because he's a moron. This guy, at least he answers truthfully when you get an answer from him.
indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just
I'm
asking
not.
a question.
So
If it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data
Mhm.
indicates the number of seconds into the key cycle that a particular event occurs.
Yes,
Is that correct?
that's correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes. The text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that. I'm reading that from the text stream data.
Okay, so in order
Are
to
you
properly
sure?
read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text.
Totality of the evidence. Actually, you don't. Actually, you don't. Because if you have the key cycle and the tech data, if those are skewed in some way, it doesn't matter what the surroundings claim. For instance, the 3-point turn. There are more than one 3-point turn between keystroke 1160 and keystroke 1164. You have the one that can read, actually said in one of her clips, they made a 3-point turn. What else is there? Well, when they took the car, impounded the car, took the car from Karen's parents' home, they backed it out, whoop, and drove it up the tow truck. That's a 3-point turn. What else is there? Well, they had to drive it off the tow truck. Backing it out, stopping, changing gear, driving it off. That is also a 3-point turn. So we are already up to 3 3-point turns. And we don't know how many others were within all of those key cycles. So which one is the correct one? You don't know. You can't know because it only registered one of them. But we know there were at least, probably, 3 of them.
Text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So again, the text stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way. Your analysis or anyone's analysis in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing event to the wrong trip, which
You are attributing all of this based on a specific 3-point turn. And we know there's 3 of them.
has a fixed key cycle,
At least
that could be a problem.
3 of them.
So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence. Thank you.
What are we looking at?
Pardon
What
me?
slide number?
I've got slide 9. Mr. Wolf, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167.
Correct.
And in this screenshot, we can see 4 text stream events.
Actually, can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was at key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that
Are you saying there's no basis for the question?
That's it.
All right, I'm going to allow the question and I'll hear it.
you are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Alessi.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with a Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped. It's because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, et cetera. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with a location where the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir.
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of course.
So you therefore are aware that the Commonwealth has maintained up into your engagement.
I'm going to see you type on this.
Yeah, for some odd reason, they choose to. Well, I understand why the prosecution objects. But all of this, he is admitting that he read the report. Even if he ignored it or claims he ignored it, he still read the fucking report. Yeah, as Euro 13 says, and we will get there eventually, that he later actually denied reading it. Even though he here clearly said that he read it. Oh.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So just 2 words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your...
Hold on, Mr. Alessi. Court reported copy.
Thank you. I will.
I'll object again. The question is coming.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr. Alessi.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question. You move.
I do not understand why this isn't allowed in. That the state has shifted their timeline several times. Why is this not. Why can't he go into this?
Part of it.
I'm sorry, Your Honor.
You have to remove part of that.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustain.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher, in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry.
In my opinion, these are valid questions. To reconstructionist who claims he looked at the totality of the evidence, well, within the totality of that evidence is that the state originally thought and claimed under in a court setting that Karen Reed hit John O'Keefe at 12:45 a.m. I don't get it. I honestly don't get it. Why they are denied bringing that up with this witness.
Excuse me. Yeah, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the page of his report.
Do you have a paper copy or do you need
I
to?
do.
If you, sir, could turn to page 9 of your report.
Sure.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did.
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did.
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess?
For the record, civil engineers don't do bridge construction. They do. It's not them who does the analysis of bridge construction and the validity of the construction. That's not for a civil engineer. That is specifically for what's the area? Well, it's not civil engineer, at least. I don't remember the area of expertise for that specific engineering.
The cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the
Thank you.
force
Mechanical or
acting
structure
upon a person
engineering.
to
Thank
determine
you.
the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I want to get. Newton's second law
Okay.
is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, you're pulling something.
Why did he pull up his calculator? Well, he would assume that they are going to talk about Newton's second law. And of course, he brings up his calculator. I mean, this guy, he is good at what he does. Problem is that he also does, I believe he's extremely biased. He had a conclusion and he reached that conclusion. Even though he himself says there is no way to say where John O'Keefe was placed in the original collision, which I say is absolutely false. Because you have, according to the data, you have the speed of the car. You also know the force, because you have the shadowed taillight, according to the state. So you have speed, you have the mass of the car, you have the force needed to break the taillight, and you have the final resting pace of John O'Keefe. With those, you can calculate very narrowly to where John had to have been when this alleged collision happened. Which, if you go by the totality of the evidence, is by the flagpole. Well, on the road parallel to the flagpole. Why doesn't he count that in his totality of evidence?
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we're going to do that. We need to do it with the court's permission. So
Sorry.
if you feel you need to do that, just let me
You
know.
can just leave it right
All
there.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, right?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 Gs of force.
That's what we actually measured
Right.
in the
And
test.
can you tell the jury what is meant by Gs?
So G's is a measure of acceleration. If you use the acceleration is measured in feet per second squared. If you divide it by 1 G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's. It's because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1 G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
Yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
And that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand, you go to scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry. 40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated. Surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture
Right.
your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No.
Okay.
Just want to get to the. That's it. Number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Can the witness see the document being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Alessi?
I do not have with me a copy of the report he cites in his reference. He did. Can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you. So I'll repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That
This is what we talked about an hour ago. He is using in his presentation to the jury to find his conclusions, to make assumptions, statistics from 1979 that head injuries are the most common injury in a car to pedestrian collision. Here's the thing, folks. That is probably the last time that data was correct. He had to go all the way back almost 50 years to find the conclusion he wanted. That most of the injuries are on the upper body and head, and therefore you really don't see lower body injuries in car to pedestrian collisions. And here, Mr. Alessi is, well, here's a modern report that says you're full of shit. Isn't that strange?
does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony
I
on direct?
thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old. Therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. That wouldn't surprise me. Car technology, especially, for example, with
If it didn't surprise you, why did you make that claim to the jury? That the most common injury in car to pedestrian is head injuries? When all of a sudden here you are, not surprised by this new fact that is at least the past 20 years, that has been the current understanding in statistics.
pedestrian safety systems has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities.
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you can test that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Maybe that's about as well.
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
Mhm.
Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know.
If you're a crash reconstructionist, why is this unknown to you? Why is this unknown to you? And thank you to Lone Star Living for being a member for 2 months. Thank you so much, and thank you for your continued support. Deeply appreciate you. Deeply appreciate you.
No, the answer to that question, is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion. That was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I
That was you having an example. You didn't explain this is according to Newton's second law. You never did.
didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no. The
Thank
general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200. Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually probably called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data.
I don't like to use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property.
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north, and slightly south and a little bit west of the flagpole.
But you didn't access that.
Does that take into account Jen McCabe's testimony that they had to turn him over? Did this take into account that they might have to have moved him to get into a better position to do CPR? Did he take any of that into account, that 7 feet in might not have been the actual final resting point? And even with that, he is still 10 feet away from the flagpole and 7 feet from the edge of the road. But the claim here is that he was on the road and then sideswiped or clipped by Karen. So we are talking about 20 feet of travel, at least. Even if we are conservative, it is 20 feet or more of travel.
Part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact.
The claim here is all of a sudden, instead of being on the road where the shoe was found at the beside the curb, all of a sudden he might be on the curb, maybe even on the lawn. Where did you get that information, Mr. Welcher?
So
I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, when you remember you had the ruler and you measured the height.
Absolutely. Yep.
Where was it? It was you in that slide?
It was
Where were your feet?
on the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground to the top toward the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration on Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so, you had to take measurements, correct?
Correct.
So
You chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin spoiler, because you don't have information that you just described.
It could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with a jury yesterday, correct?
That is not correct. You asked me 2 questions. I absolutely considered the berm. And the second question when I presented to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you
Huh? For fuck's sake. According to this, to Dr. Welcher, spoiler hit the eye or the eyebrow or the something at roughly 20 miles an hour. And all it did was leave a laceration, a tiny, tiny laceration. It cut open his entire arm on the taillight. It removed paint from the Lexus, hitting the hip of Mr. O'Keefe, and the 1/8 of an inch cut on his knee was from the bumper of the Lexus, according to him. How is that a sideswipe when almost every part of the side of his body is hit by a 5,700-pound Lexus? Where are all the bruises? Where are all the bruises? If that is your conclusion, where these injuries might have happened, how is that still a sideswipe? If all those parts of his body, the knee, the hip, the arm, the eye, was hit by a Lexus, close to 6,000-pound Lexus, going at 20 miles an hour, where's the sideswipe? Where is the sideswipe?
You can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car. I could probably find the slide for you.
So you didn't do a force analysis to determine how much force would be applied assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what.
Part of what they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct. If we had more information.
You had it.
Why don't we break in?
Thank you, Your Honor.
You had enough information to try to claim that all of that part of his body was hit by a Lexus. You had enough information for that, didn't you? Jesus fucking Christ. All right. Lunch. Skip ahead. And here we go. Cheers.
Go ahead, Mr. Alessi, whenever you're ready.
Just take a moment, Your Honor, to reorient. I'll be right. Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same. We had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones.
Yeah, we know he misspoke again.
You can conduct a force analysis
So your
on any
bones are on
bone.
the inside.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis on any bone in the body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now, given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got,
Just the hand?
just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm, is from the shoulder down to the tip of the fingers, is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing.
Did you notice how he tried to qualify? He tried to qualify. He always does this. He tries to qualify his answers and make Alessi change his question so he can qualify his answer and continue it to be vague.
Impact, is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really what, I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. So let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay.
Tell me when you're ready, sir.
Go ahead.
So let's take a scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for the impact window.
For 180,
F of force in the F equals M times A calculation.
about 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical semi-algebraic application of the numbers, correct? You
Correct.
divide,
We're doing a little simplification in terms of the crash
Yeah.
pulse shape, but generally, yes.
so, but let's take the conservative number, the lower number, 2188 that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force the F you would get to have to cause a break of the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a
And he qualifies his answer.
high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to
No.
do your calculation?
No.
I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, excuse me, any of the hand bones, you know what I'm referring to, the phalangeals,
Yes.
the metacarpals, and the carpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
No, I understand, but I'm asking, do you know from the literature, not a calculation? Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load, a load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're gonna need higher.
How about another part of the back of the vehicle?
I
This
guess
part,
if you hit
I think was a hit
on the
and miss
very
by
corner
Alessi
and it wasn't a distributed
for the
impact,
next
like if you had a more
15,
concentrated
20
impact,
minutes.
Yes.
that could increase or decrease the amount of force required.
How
Because
much would it decrease it from?
because now Welcher managed to qualify and make Alessi change his questions enough for his vagueness to be the answer.
The number you gave?
Depends on
So
what you're
even though I do believe Dr. Welcher is a sneaky bastard, he's really good at what he does. He's been doing it for close to 30 years. And in civil litigation, they are much, much meaner than in criminal law.
hitting what it's made out of.
The
Contact
Lexus
area.
SUV. Let's assume. I'm sorry.
Les, can you repeat the question, please?
Absolutely. Thank you. Let's assume we're talking about
This Lexus SUV,
Mhm.
right? But let me back up. You don't know where exactly, under your theory, that there was contact. You don't know, you testified to on direct, you don't know exactly where that point of contact is.
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the tail light, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see any impact, right?
That is correct.
So, and there is no firsthand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, right?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities. I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was.
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light, that it is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the tail light.
Sir, then you're going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay, so you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion. But that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the tail light at the scene around his body circumstantial information?
Sir, let me go to the force and
Go back to the force analysis. Let's go back to the numbers. I want to state.
I hope to everything holy that Alessi is gathering information for ARCA, because all of these testings that Welcher says he couldn't do because he didn't have enough data, I hope that ARCA can just walk up to the podium and say, oh, that's easy. Here's how you do it. But this guy is good. And we don't know how the jury takes this guy, how they feel about Dr. Welcher. I can't say I'm not worried, because Dr. Welcher, even though we all see all the flaws, I'm not entirely sure the jury does.
On, if we can, just the calculation. So let's go back to the minimum amount of force. You understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with the hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading. You will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight, Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers,
Okay.
okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone. But as you got above 350, you started to break bones.
So as you got above 350,
300.
above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds. So you are 1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you
Then how the fuck did the taillight explode?
calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't, what was it? You said, you said
2,180
dyslexic? Or did you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear
You
it.
came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay,
absolutely
so let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows
I don't know what to say about his assertions because we have his word for it.
it only takes 300 to 400
That's
pounds
it.
of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed. But what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I distributed it over a larger area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay, so probably
I don't like this line of questioning here because he says any part. Well, it has to be within reach. So I'm not entirely comfortable with this line of questioning unless he already knows what the ARCA guys will testify to, and that they can absolutely rebut this jackass.
your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper, potentially, yeah. But from a taillight or a broad flat surface, no.
I'm not asking about taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include.
It doesn't matter if you think it's incomplete. Just answer the fucking question. And I'm a bit saddened that this is partly Alessi having this habit of allowing witnesses to talk themselves into something he can use. Dr. Welcher is a bit more skillful in being evasive than any other witness so far in this trial.
Taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger. So your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the taillight.
Okay, what we're going to do to make this more efficient, Mr. Wolf, can you pull up a slide from Mr. Wolf's or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number though, Mr. Alessi?
Mr. Wolf does, and
And
I
then
know
he'll
you
tell
need it, so
us.
he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here
Yeah.
instead of just up there.
The back hatch, yes. You have one of just the rear gate. The one measuring the height. Maybe. There we go. Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit 300 to 400 pounds of force could break it? Is there any part, for example, the edge?
A question I would have asked if the glass shattered through the force of the impact, why is the palm of his hand not sliced open?
Edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated. Anything you see there could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand.
So, I don't know how to show this because in the middle photograph, right where that 2 is on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right. So now let's go from 300.
In my opinion, if this is what he claims is a side swipe, well, the taillight curves, doesn't it? Which means it's not a flat surface. At one point, the curvature is you have a very narrow, like a wheel, a very narrow point of impact. It's not a flat surface. Would that narrow point of impact break an arm? I would suspect it would.
To 400. Let's go to the 2188, which is your number. Use
Thank you,
2188.
Kelly. Thank you so much.
Is there any place where
Saying,
in
I hate him
2188
so much.
force
Yeah,
you could have a fracture of the hand on that
really
that gate?
Just to be
don't
clear,
like
2188
Dr.
is the number I
Welcher.
calculated for you. It's not, quote, my number.
I understand, but we did.
So-
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about because we used a weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that
I'm sorry, but to the hand?
to-
Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you see the little dot, I'm talking about this area.
Yes, yes,
Going
right here.
into
Yep.
the
So that transition between the two body panels,
yes.
that could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well, it's a much more narrow loading condition.
How about the corner of the tail?
hello, Mr. Jingles.
Corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Ah, thank you, DSN, for your $10 super sticker with a guy with purple hair going, oh, or something. I don't know. Thank you so much, DSN. You are a very, very good supporter of this channel. Thank you so much. And Dave's here.
Any of that force analysis for this case?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108.
I'm sorry, Your Honor. Yes, Mr. Wolf. Yes,
All right, thank you.
thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray from the records I've seen, either his hand
This is insanely stupid, especially what happened at the end of the day. So I want you to remember what he is saying here regarding the autopsy report and what he claims has a lack of stuff in it.
And or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe,
Yes.
other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So, are you aware that medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, it's a question, that Dr. Shorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there'd be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I need you to prove my question.
You're asking me about the opinion of a medical examiner. I'm not a
Hold
medical.
on. Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
You're right, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for
I
medical.
understand. I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record or autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
Except for the skull.
Correct.
Do you understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Shorty Bello, in the conclusion she reached in the autopsy report that you read? Did you read the conclusions of Dr. Shorty Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Shorty Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
The doctor has already testified. He claims he read the report carefully enough to know that there were no x-rays of the arm. Why? And he is an expert. He is allowed to speculate on information he has. Why the fuck is this being objected to and then all of a sudden a sidebar?
Talk now about, may I, Your Honor?
Yes.
Thank you. Dr. Welcher, I would like to talk now about your paint.
And apparently it was sustained. Thank you, Dave, for $5 because I had some leftover money after paying Arca. All right, that gets us to $33 for the spin on the wheel of regret. If you haven't seen that before, it is this one. I have narrowed it down as to what kind of. Normally, I have hot sauces and stuff on it, but today it's just different kinds of shots. Because I have tomorrow off, so I can I can afford a day of a slight hangover.
Exercise. You did not present, as you have stated, a force calculation with regard to the arm. You did a paint exercise. And what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Okay, you want to call it a blue paint test?
Sure.
Okay, let's call it blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Okay.
So your blue paint test involved painting the right rear taillight blue, correct?
Correct.
Positioning the test subject behind the taillight, correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
This is a good question from Mikkel's headphones. He's so bad, I don't understand why anyone would hire him for a criminal trial. Because he will say what you want him to say. Those kinds of experts are in high demand. If anything, I believe he will be hired more after this trial. Not Burgess, he will.
I know. Well, let's just do each one at a time, okay?
Okay, so start with the last one.
That's the
I'll start
sad
with whatever
truth.
one you want.
Okay.
How about if we start with the one at 1 mile per hour?
People like him are in
1 mile
high
an hour.
2 miles per
demand.
hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that, okay? Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus taillight on that arm?
So generally, I want to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that Mr.
And still, you never did a calculation regarding what force it would take for that right back rear taillight to not only crack, not only break, but to basically explode, and where pieces landed somewhere between 10 and 25 yards away. Where? And thank you, Kelly. All shots on the wheel, I'm in. Thank you so much for your $20. Thank you, thank you, thank you. That gets us 25. We are $13 away from a spin on the wheel. $13.
Or excuse me, that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No, where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mhm.
Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you?
Of course.
Do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with the Lexus at 20 miles an hour.
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You
If
could have
you-
done that.
If you use the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, if you damage the car, you have to know everything about the parameters. And so again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
So your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis.
No, there is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
You know, you have a hypothesis at what speed you believe there was impact. You have a point of impact.
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
Let's talk about the other information you don't have.
Okay.
You don't have the information as to from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
You don't know that. I don't know the information.
How can you not know where on the road? You have testimony that Karen's car was roughly, it was by the flagpole. You have that statements from several people. By the flagpole. Why can't you use that? If that is according to the state, the most probable point of impact, area of impact. Why can't you use that? Why do you keep saying you don't know? Again, I've said this earlier. You have roughly where John landed. You have the taillight pieces. That with the taillight pieces, how much force would it take the taillight pieces to travel that far? You have the speed of the car. Or 1, 2, 3. Now you can triangulate. What must have happened and where? But if you actually calculated by these 3 points that the state claims happened, I think you did. And the answer was that it couldn't have happened. Yeah, 87 feet. Yeah. From stationary, driving forward 34 feet, backwards to the more or less the exact same point. How did you calculate that? And then an additional 53 feet or something. A combined 87 feet. Here's the thing. 53 feet at the same speed and only a 10-degree movement of the steering wheel would, if you actually calculated, oh, this is from within 5 feet of the flagpole, that would still have Karen Reed's Lexus crashing into cars in the driveway. And I think you know this, Dr. Welcher, and I think that is exactly why you now claim you can't calculate it.
Okay, nope.
You don't have that. You don't have the point of impact. You don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information.
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
I don't have where it started.
The paint tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was.
You are not the same height as John O'Keefe. You don't have the same body type as John O'Keefe. Using yourself instead of an actual replica in the shape of a crash test dummy, that made difference, a biased difference.
So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right, but my question, sir, I understand you use paint tests as the focal point, but aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the middle of the event.
Give me the chart, please. Your Honor, I'll give you the, as soon as Mr. Wool gives it, the slide 23, I believe it is.
I'm sorry, what slide?
Well, I want Mr. Wool to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, there was like a 30-something number and a 50 number and you came to 87? Do you remember that in your slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
Are you on 33, sir?
William says, to be fair, he's about half an inch shorter and not that much heavier. That's his claim. And still, he really, really had to stand up and tilt his head upwards to even be close to having his eyes. I mean, yeah, this is why you don't use yourself as an example. You will either found the exact measurements and then you do a model. You do a simulation, a computer simulation. Because he was perfectly able to do a computer simulation with 3D scanning, laser scanning of the two cars, a 3D rendering, and then a simulation. And folks, that part of this, I would estimate that as costing roughly $30,000. That simulation in itself, with everything that went into it. But he couldn't do a simulation with Jan's actual measurements. I think there was a reason for that. One, he's vain as fuck. He wanted pictures of of himself with the car. He wanted to bill the hours to himself instead of handing it over to one of his computer guys who did the simulation. Yeah, no.
No, I'm on 36.
Mr. Wolf, you have 33. If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the
It's
other.
on a bunch of slides.
Yep.
Go ahead.
All righty. So if you could zoom in, Mr. Wolf, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep, to the farther to the right.
Oh, I'm not the only one that has problems.
Okay.
You
Sir,
still
do
don't
you
have it.
remember testifying about this? To the farther to the right?
Farther to the right.
Yep.
Keep going. Keep going. A
Is
little
that
more.
53 number down there? That column?
Right.
So
can,
if
we,
you take-
can we scroll up a tad so you can see the headers? There you go.
Okay.
No, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns, like Z is relative to where it started. And then positive is forward. And then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet,
It's in two spots. It's at the end of column Y.
right? We go all the way down. Is that in the yellow there? Is that 87, sir?
It is.
Okay, is that the 87 number you were
Hold on a
referring to?
second. You asked me to identify. So then it's see where the one next to it says minus 53.429.
Yes.
If you go up, so it's not a little bit down, a little bit, and add, see where it's changing directions at 34.157.
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50 something feet backwards.
Right. And what is the 87 feet traveled? Is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe 87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now, Can you
Just hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How many feet did you say on direct, and did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward, then it went in reverse.
This is a really extremely easy question. What was the total amount of feet it went in reverse? And you say it yourself, it's 87 feet. Now, the point where it starts, it drives 34 feet forward. Then it starts to back up 34 feet to the alleged starting points, plus an additional 53 feet, 87 feet in reverse. Here, maybe the jury starts picking up. Why can't he just say 87 feet? And here's the interesting part. If 30 feet forward and 30 feet in reverse to the same starting point, which I assume is somewhere around the flagpole where the state claims the collision happened. How the fuck does a Lexus get from 0 to 24.2 miles an hour in 34 feet and then continues to drive backwards another 50 feet, which, counting from the flagpole, she would smash into cars in the driveway, driving over the lawn, because the curvature of that bend does not equal a 10-degree turn of the wheel. With that turn of the wheel, she can't make that bend. She doesn't make the curve. She will be driving up the lawn and then smash into the cars in the driveway.
How many feet do you believe the Lexus went during the trigger?
So it went a total of 80, it went 34 feet forward, then it came back 80, another 53 feet past where it went.
Exactly. So you've testified that the 1162-2 trigger event represents a backwards maneuver, correct?
So again, clear, it initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
Could you zoom in? There you go. No, go back to the left. So that T in the third column for data ID represents the trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is this 10-second window. And so we have the velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicles.
But you have been saying 30 feet, 4 feet forward your entire testimony. How can you now not be certain?
Speed.
I see it.
So at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. you can see you have the brake, where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way. Are you certain that the distance traveled forward during this trigger event was 34 feet? Are you certain?
I'm pretty certain during the trigger event.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible. I would say I'm certain,
Okay.
but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet. And is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
And a 0 represents neutral,
I think it's either neutral or park. I'm pretty sure it's neutral.
a 1 represents drive,
Correct.
a 2 represents reverse,
Correct.
or a 2 can represent slowing down. Is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down.
I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay. So if Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolf. And I want to do it generally. There's not a need to read any specific number. I just wanted it clarified.
Mr. Alessi, so is this 30 or 31?
Yeah, I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you. You see all the numbers in blue font on that slide, sir?
I do?
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do?
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet. That correct?
Correct. The one exception is column N, where it says shift position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct?
Correct.
As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Now, we're going to keep that up, Mr. Wolf, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage. Is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35. So
I've highlighted the slippage.
exactly. So you agree that there is data that shows that there is wheel slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%.
So let's
In reverse.
Okay, got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
It doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depressed greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm
Oh,
just saying a correlation. Do you understand what I mean by a correlation?
Let me, if I may try and straighten this out. So applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Alrighty. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at sidebar on this.
Why? Why sidebar? All these sidebars. I haven't been keeping tabs of it.
May I, Your Honor?
Yes.
Thank you.
But this is in
Dr.
YSL
Welcher.
territory of sidebars.
Am I correct in my understanding that you believe under your theory, the Lexus for event 1162-2 backed up 53 feet? Am I correct?
No, it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87. Okay.
Correct.
You were asked that specific question half an hour ago, and you had to mumble out, well, no, 34 forward, and then back to the starting point, and then an additional 53. You try to mumble, and all of a sudden, yeah, 87 feet. If you answered the question properly half an hour ago, this would have been so much easier. But you have to contest it every damn step of the way.
And your further theory is that it did so and reached 24 miles per hour, correct?
Correct.
And you stated you have an understanding of a certain number of people, and I don't want to talk about the inside of the house, but just that were at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Did you want them people that were there for that entire window of time, or just?
Yes, 12 to 1.
So Mr. Alessi, just move to the last question.
Right, sure. So, sir, did you assume that there were cars parked out front of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
The entire time?
No, I'm just talking 12 to, yeah, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any assumptions with regard to that?
At a point in time, there was a vehicle behind it.
I'm sorry,
There was a vehicle behind it.
just one?
That is my understanding. In terms of on the street. is
On
your
the
question.
street,
Yes.
I thought you took in all the testimony, or did you just take in the ones that suited you?
And what, do you remember the type of vehicle?
Yes.
What kind of vehicle was it?
An F-150 pickup.
Did you have any understanding as to whether there was a Jeep vehicle on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep type vehicle on the front, out the front of 34 Fairview between 12 and 1. Is that what you're recalling?
So I'm going to let that answer stand what he's just testified to. Just go ahead and.
Okay, so Dr. Welcher, what I want to do is to have you, using your data, you say 87 feet for the backup, correct?
Right.
1162, up to 24 miles per hour. Isn't there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision of the Lexus SUV with a vehicle out front?
No, the vehicle had left prior to the end or prior to event 1162-2.
What information do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Ms. Reed's interview statements. I have statements of a number of witnesses. I don't know if I'm allowed to say the names.
I was just going to say, let's not just number of vehicles.
Okay, so I have a number of witness statements at multiple statements from the same witnesses at different times, indicating the path and following the Lexus to the house and then leaving before the event.
Assume that there were vehicles, at least one vehicle parked out front of 34 Fairview. Is there a likelihood that given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60 something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I need my slides,
It was 50.
50,
Okay. Yeah, go ahead.
57. If something is within that window, then it would hit it.
All right, good. So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go up upon the lawn in front of 34 Fairview?
It depends on where it starts.
You have an opinion, don't you, as to where it starts?
No, I do not. That's actually why I have that diagram.
This is one of the things that is really it's pissing me off. You have the data needed, the data points needed to make a qualified, informative calculation. Where did John, according to the state, where was John found? Where did the shards go? How much force does it take for shards to travel that far? You know, the speed of the Lexus. All of that, with that data, you can make a rough calculation together with the witness testimony as where the starting point was, because almost everybody said she was parked close to the flagpole. So why don't you want to calculate this, you moron? And again, let me repeat myself. It's because you probably already calculated it and found out that there is a more than likely chance with the 10-degree steering wheel and not actually braking once you got up to speed. You only know that was the end of the cycle. So according to the data you have, if you actually did the calculation, Karen's car would probably crash into the cars at the driveway. And that doesn't make sense because there are actually no tire tracks on the lawn. It's almost as if this didn't happen.
Showing it off to the side.
That's
I'm
right.
simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started. And therefore, all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles.
Right. So if anybody's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when there's a storm that is beginning?
No.
Have you ever done it when there is less than clear visibility?
No, and
So you didn't replicate the conditions of the event.
no.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the snow, I've done it. But again, that's been decades.
Right. So 87 feet, 24 miles an hour. Are you saying that in every instance that vehicle will stay on the road and for 34 Fairview, it wouldn't go up on the lawn?
When you mean every instance, mean like every possible location on the road it starts from?
Correct.
No, there's some spots. If you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described, right? The
Conditions have
weather,
nothing to do
I
with where
need
you
to finish
start.
my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his question, please.
Given the conditions that you've described, it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur a vehicle going 24 miles an hour at this location, 87 feet backwards, in the dark, with wet pavement at a minimum?
First of all, how can you say no if you don't know the starting point? How can you say reasonably no when you don't know the starting point?
In low lighting, you don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn. That's not
So
possible.
your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side,
And now he starts to, but if it's close to but you have the witness testimony. She was parked by the curb, by the flagpole. You have witness testimony to this. Why didn't you do the test to find out if it was possible?
Then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah, highly, highly unlikely. But
Right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So in terms of
In the realm of possibilities, in this scenario, according to him, the Lexus could have been shot up to space. Not under these circumstances, right, Mr. Welcher? You would need to attach a rocket. There's no evidence of that, is it? So, is it really even as an engineer, can you really claim that? No, you can't. And then the comment, let's get back to reality. Beautiful.
of the Lexus itself, because you, under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
If not, no, it could have.
Okay, now let's go to the next topic. If we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167.
Yeah. Yeah.
Now, as I understand your testimony,
He was
Dr. Welcher,
hired to come to a conclusion.
you believe that it's possible that the Lexus taillight could have caused these wounds to Mr. O'Keefe's right arm. Is that correct?
Correct.
And more specifically, it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know. I characterize it that way.
Notice that most, if not all, of these lacerations goes in one direction. And remember, in his scenario where the paint was blue, his arm was more or less in a 90-degree angle.
Happens is, the 6,000-pound vehicle is coming and he's standing on a, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Right. So it's going to contact him and, under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
Sir,
I'd like to answer your question with a slide that I have that addresses this exact point.
I'd like to stay with this slide, Dr. Welcher, and see if you can answer my questions off of this slide. So I'll repeat it.
Sure.
Do you agree that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones.
I know it's not your fault, but
On the
sometimes it
image,
doesn't.
the upper left. I mean,
Yes.
technically, the ones right to the right of that are also on the biceps and triceps.
Right, but
the
I'm talking-
biceps goes all the way to the elbow, so do the triceps.
Right. So I'm talking about the two that are the farthest up.
Correct.
All right. Would you agree that those are in a horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this and the tail light coming across like this, which is what I showed in my slides.
My questions are trying to keep this moving. I just asked if those are in a horizontal orientation.
Yeah,
Yes
more
or
or
no?
less. They're angled down slightly, but more or less horizontal.
Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with the test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration.
Yeah, but what about the lower arm? What about the lower arm that you held in a 90-degree angle, just as you do now? Why aren't those? Let's go back and see. Where is it? Where is it? All of these goes the same direction, horizontal. If the arm is in a 90-degree angle, this means that those laceration goes this way, and those lacerations will go that way. It does not compute.
To the forearm.
Correct.
Gotcha.
Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle. If this is me and this is the car, it's pushing and pushing across like this. And with your arm bent like this, it's going to cause laceration as it pushes my arm away. It pushes like that.
Okay, I got you.
My slide shows this quite clearly.
So you disagree, you do not agree that the injuries to Mr. O'Keefe's forearm, under your theory, would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
What I'm trying to do, sir, is to get under your theory,
Mhm.
right? Given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay.
This line of questioning here, I assume, is because of what ARCA will testify to. Most of this cross-examination is in preparation of the ARCA, guys. And no matter how good I believe this guy is, the crash daddies are likable. And they talk with people, not down to people.
Isn't it the case with your theory that the tail light would have to break? And after the break, the arm would have to maintain contact with the arm as the car moves.
So that is what happens in pedestrian contacts. There is a contact duration. For example, you asked me earlier in that calculation.
Only if the body follows with the car. You, in your testing, showed that there was an immediate rollover. Immediate. So where was the follow?
You had me ran, you said 0.01 seconds. That was the contact duration. So when you have things like this, that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body. It's going to cause it to move. The body's going to rotate away, and the car is going to continue on in that clipping type impact. So the arm is definitely in contact with the rear of the car for some time.
That's what I wanted to get to, is simply that under your theory, the taillight would break, and also the arm would need to maintain contact with the taillight area as the car moves. Is that your supposition?
So at a point in time, it'll stop contact, but the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next question is simply, how long do you believe the arm needs to maintain contact with the taillight after, under your theory, it breaks to produce those types of wounds that you say came from a taillight?
We don't have enough information to determine that.
Right. You don't have enough information to make that determination, do you, sir?
Correct.
And-
But we know because of the laws of physics that it has to be some amount of time. It doesn't occur instantaneously.
So now we do apply the laws of physics to the right arm that weren't applied before because you applied to the experiment. Is that correct? You're now applying the laws of physics to the injury to the right arm. Because you
No.
didn't do that in your report.
Nope. Always apply the laws of physics. The paint experiment, as you're referring to it, was to look at basically the orientation of the scratches that matched this. So that was an engineering experiment to correlate height, position of the taillight.
Correlation does not equal causation, folks. I'll give this example. Ice cream correlates to drownings. How is that, Nick? Does ice cream cause drownings? No. It correlates because ice cream sells more in summer and more people drown in summer. That is the difference between correlation and causation. Correlation, unless you have more information, it means jack shit.
Relative to height, orientation of the lacerations on Mr. O'Keefe's arm.
You just said, sir, if I heard you correctly, to answer my previous question, applied the laws of physics. That's what you just said, correct?
So the laws of physics cover more than Newton's second law. There's a whole law of physics. The whole field of physics is a broad subject. So a simple measurement of height is a physical measurement.
Sir, I have your entire report in my hand, right here. Where in the report do you apply the law of physics to the right arm of Mr. O'Keefe? Where?
So in the paint experiment we did, the laws of physics about gravity, orientation, things like that, I didn't apply.
What's the fucking formula, you twat? You never put in an actual formula. You just made a photo op.
Newton's second law, as we already went through. But again, those simple position arm angles, the possible physical arm angles, those are all generally governed by the laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way. Where in your 14-page report do you even mention the laws of physics related to the right arm of Mr. O'Keefe?
So in terms of applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law of physics relative to the right arm? Can you point me to where?
Would write a report that said these are the laws of physics. I would say these are the numbers. But for example, the timing in GPS, how a clock timed, the concept of a second.
This is not concepts. You are a crash reconstructionist. You don't just put a number. You explain how you got the fucking number. That's your fucking job. And you didn't do it.
What does that mean? Those are all concepts of physics. So the timing, the GPS, the mileage, how we calculate the mileage, those are all based on the laws of physics.
I'm talking about injuries to the right arm.
It's not what you asked. You asked me about my whole report.
Sir, if you could, please, I just need to finish my question. Where in your report do you use any laws of physics in connection with injuries to the right arm of Mr. O'Keefe? Can you point me to a word or a page in your report?
Yes.
Where?
2A, 2A Roman numeral 1, 2A Roman numeral 2, 2A Roman numeral 3, 2A Roman numeral number 4, 2A Roman numeral number 5.
Sir, I followed all of it, but what I'm asking about is where in all of what you just mentioned is the word right arm? I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
So let's go to 3. You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right tail light of the Reed 2021 Lexus LX 570. Where?
Can you read the next sentence?
I'm sorry. Is it C PowerPoint slides 102, 120, correct? All right. I want to just start with the report. Did you apply any force analysis to support 3?
So in terms of the force analysis, I did not do an F equal MA analysis, but in terms
That was the question, twat. And you didn't do it.
of, say, the contact pattern, I obviously had to apply some force, even at 2 miles an hour, to do that.
So the answer is what you cited, number 3, you did not use a force analysis, correct?
So force was applied to my arm in the paint test. I didn't do an F equals MA force analysis.
Thank you.
You're welcome.
So now let's go to the horizontal movement we were talking about with regard to the car. And you can agree or disagree.
Sorry.
I'm sorry, we'll take that down. Do you agree or disagree that given a horizontal movement of the car, vertical lacerations would be an inconsistent injury pattern?
So horizontal motion generally will cause a horizontal laceration. You can get what are called stellate, which are a blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause horizontal lacerations. But when you have a fractured taillight, you can get pieces going off in other directions. So it's not necessarily going to be perfectly horizontal.
So my question is, not with clipping, you keep inserting clipping into my question. My question is this. If you're given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent injury pattern?
I'm trying to help you, but you got to give me more. So like, is it a clipping contact or is it not a clipping contact? Is it a direct in the center of the car impact?
Okay.
The contact of the arm with the taillight that you claim, oh, this shattered the taillight. Where's the formula? Where is the force used? Where is the force needed? Now, there is claim that this might crack and destroy the taillight in speeds above 8 miles an hour. I don't think that is even remotely true. I will give you an example. In the European Union, you have to reach some really, I mean, we are talking about California type safety. I mean, you unless you meet them, you can't sell a car here. And this bozo is trying to tell me and you all that somehow a taillight breaking and exploding shards everywhere in speeds above 8 miles an hour would be approved? Oh, fuck no. Mr. Jingles, my chair is not a scratch board. Well, it is. It became that more or less the day after I assembled it. Hello, Mr. Jingles. Can Lexus sue Aperture for slander? I don't think so. They do, and they should present their, because I can 99.9% guarantee they have actual numbers. Problem is to get the numbers from them.
Are there only two variables you need
No,
to answer the question?
But this is a good start.
All right, so let me do it this way. You can't answer the question on a general basis of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations, but again, it depends on what's being hit.
Okay.
So for example, if I have something that bends as a result of the impact, it could bend up and create a vertical laceration.
So you would agree, based upon what you said, that generally horizontal movement of a car would be expected to cause horizontal lacerations.
Generally.
Okay. Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the test.
Do you want, we bring up a slide? Will that
I'd
help
love to
you?
bring up a slide.
We're going to be running the thing, so we'll just bring one up and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
If we could take a shot at it first, and then we may ask you for it, but I think we've got a slide for you. And what number? 111 is on the screen, sir. Is the blue paint more predominantly on your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
Probably. This is the one where I actually walked sideways into the back of the car. The one where the car is moving is probably a little better representation.
Sir, I'm just asking you a question about this slide. If you
Okay,
could just focus on this slide here, and if you can't answer it, so be it.
I just answered it.
Is the blue paint featured more predominantly on your upper arm than your forearm?
It sort of looks like it. I didn't actually measure the total area of it.
All right. So on direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with a taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes. So isn't that an example of confirmation bias?
No, that's matching the contact pattern to the injuries.
Every time he does an actual lie, his ear itches.
But don't you have to select among other choices this outstretching of the arm? You had to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion to hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes, you
asked.
have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right. I am not going to be asking any questions.
The
involving
tailpipe
taillight
is
in any
part of
fashion.
the
So I'd like to go back to
undercarriage.
the question that I'm asking,
Mhm.
which is, did you consider, as part of the scientific method, in terms of more than one hypothesis, did you consider in your analysis any other orientation of Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was.
This is good. And it took almost the entire day. He never actually tested any other hypothesis but the one that matched the prosecution's case, the prosecution's theory. He never actually tested another hypothesis. Never. Not even to exclude it. He just never, he claims he never tested them.
It was up on the sheet metal.
Okay. So are you saying that you considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some slight different angles in the forearm, which is from the elbow to the hand. I did consider that, but all the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternative orientations?
No, I think I just included photographs of that damage.
Do you have any proof at all that you considered those other orientations? Anything you like?
No, I don't believe so.
All right. Did you consider any other locations of Mr. O'Keefe under your theory relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. It could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight in a Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific method earlier has the scientists
That-
identify various hypotheses?
Folks, that's not true. One of the major parts of his direct examination was to debunk or try to debunk the impact between the Traverse and the Lexus. So,
Go over the data that supports it, but you show your math as to why you're rejecting hypotheses. As you said, you rejected that. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with the Lexus. I did backing tests. I looked at how the rear system worked to see if it would autonomously brake. I confirmed it did not. So I eliminated that as a hypothesis. I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
I understand you say you did a bunch of tests on the vehicle. My question is,
Mhm.
did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do 1 static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
All 3 tests was to confirm or try to confirm the state's theory. You didn't try to falsify it. Most of the scientific method is about trying to falsify your current position. And you did fuck all. Absolutely fuck all. And folks, K. Schmidt gifting 5 memberships. And that finally gets us to the wheel of regrets. Dun, 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 da, 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 da. And it's a whiskey shot. It is a whiskey shot. It is a whiskey. It is a whiskey. It is a whiskey shot. And I'm having a whiskey with a screw cork, which is a sign of quality. And my Bucky's shot glass. And a cat on my shoulder. Hello, Mr. Jingles. Thank you, K. Schmidt. Thank you. And it went to D. Robertson, Chloe's mom, Scorpion, Gavel Guide, and Mirage of Reality in MN, Minnesota? Michigan? I don't know. Cheers. Oh, this is a local Swedish whiskey, Ven Old Hare. If you find it, get it. It's a blended whiskey. It's smooth and it's good. One of my go-to whiskeys. Mr. Jingles, hello. All right. Thank you for putting us over that edge, K. Schmidt. Thank you so much. And okay, here comes Brooklyn with 5 more. Okay, and Unicorn saying cheers with 10. Okay, where does that brings? Oh, I have math. Let's see here. We have 2, 12, 17, 37, 52. That puts 2. Okay, plus 15 is 17. Plus 10 pounds. That's like $12. So let's see here. 2 past. Plus 15 is 17. Plus 12 is 29. So we are $21 from the next spin on the wheel. What did I see? I saw a comment here. Let's see. Go says, Mr. Jingles hitting the forehead kiss. Let's see. Hello. He was not expecting that. And hello. Hello, Mr. Jingles. Hello. That was a positive reaction. I should have done this before. Hello. Oh. Now you will demand kisses on the foreheads for the rest of my life. Oh. All right. Let's get on with it.
Arm.
Where's the documentation for that, sir?
It's in the file. I gave it to you. Some of the slide or some of it.
So, Mr. Alessi, I think if we're going to,
I'm going to move on, Your Honor.
So
okay, but Mr. Alessi, hold on, we're going to do that for you.
Can I ask,
I just have one other area, Your Honor. I can do it in short order if I could, please.
I wasn't finished my
Go ahead, finish your answer.
So slides 109, 110, 111, actually through, I guess, 121 deal with.
Yeah, this is Welcher desperately saying, I tried to falsify my conclusion. No, you didn't. You never try to falsify the conclusion because you had it from the start. Unicorn 11, the perfect break from testimony. Member for 21 months. That is amazing. Thank you so much for your continuous support. Thank you so much.
With the testing of the hypothesis.
We'll come back to this at another time, Dr. Welcher. So what I want to do is to finish up on this point. So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation? This would be my last question. Did you engage in any confirmation bias in terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a good
All right,
opinion.
so, okay, thank you. All right, so jurors, we're going to send you home because
That is a good final question in front of the jury. Because tomorrow is a half day, so I assume he is going to continue with it. Now, folks, it's a tiny, tiny voir dire of Mr. Welcher. And in this, he will make a comment that is so inflammatory. And if this doesn't tell you bias, I don't know what doesn't.
we still have work to do here, and we don't need you waiting there while we do it. So tomorrow is a half day. We'll see when exactly that half day ends. but
Hey,
we
Stringer Bell.
won't go until 4 tomorrow.
Hello.
Those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation.
Yeah,
into this
let's
case.
skip ahead to the voir dire.
Can I have a moment, Your Honor, to switch?
Because it is voir dire. It's a French word. It's not voir dire. Hey, Dave, a member for 10 months, saying, I'm a member, you should be too. Yeah, it's $3 a month. And for that, you get a lot of members-only content. You get your own emojis on YouTube's. And you get access to my Discord where you and all the other members can discuss the cases I cover, snark, memes. It's open. It's open. Pink Slime says it's old French. What here? All right, let's
Yeah,
see.
can you do that while you're sitting here answering questions? Yes.
I'm going to do this in a slightly slower speed. If you didn't know, we have been playing this in 1.5 speed. That is how slow everything went in court. So let's go down to 1.25 to give yourself a chance and an opportunity to muster the final $21 to the next spin on the wheel of regrets. War to see, tired to say. Yeah, voir dire.
I'm going to start with Your Honor with regard to the truth ball.
Okay. And we're on a very limited schedule here. Okay.
This is pissing me off. It is a voir dire, a crucial voir dire. And she tells them to rush it. No, what you're supposed to do is to skip today's happy hour at your favorite White Claw spot, Judge Bev, or give them time tomorrow morning.
Yeah, Your Honor. Mr. Wilk, with Your Honor's permission, if we could pull up the January 30th, 2025 PowerPoint of Dr. Welcher in slide 36. You see that, Dr. Welcher?
We are down
You
to
recall that from your January 30th,
$19
2025 PowerPoint?
to the next spin on the wheel. Thank you, Stringer Bell. Thank you so
I
much.
thought I had replaced the video on the left-hand side by the time I produced it.
Sir, I got to
don't
go through
recall
this
that.
quickly. That image is a drone image on the left, correct?
Oh, correct,
And you had that in your original report, but you removed it in subsequent reports, correct?
correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that
So he believes it was, and then he starts to change his mind because this is pissing me off. And even though it might have writing on it, the image is still the one in the report.
drone image from the CARS report of Trooper Paul, correct?
Correct.
Let's, if we could, Mr. Woke, go to diagram 1. Do we have that electronically of Trooper Paul's report?
Oh, by the way, June 6 is our National Day. June 6. That happens to be a Friday. So not this Friday, but next Friday will be a combined. What happened if the trial is still ongoing, it will be what happened in the trial this week, a celebration of our National Day, and a slightly buzzed Friday panel show. Ooh, and I have to tell you this also. Me and Daniel have talked about the Koberger trial. And we are in somewhat agreement that trial will take a long time. And remember the YSL trial, how I conducted that one? Recaps and Friday panel shows. So on that trial, when it actually starts, it will be the same thing. I will do recaps and Friday panel shows. And thus far, it's me and Daniel. I suspect the Hella, Excited Utterance, have an interest in it. I know that a bunch of other law tubers will definitely cover the trial. So, yeah, as Mika says, if it starts. Yeah, but regardless, if it starts, we will have the entire package for you with the premier law tubers covering that case, gathering together at my channel on Fridays for a panel show on what actually happened. So that will be really, 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 really interesting. Okay, but back to this trial.
Do you recognize that as diagram 1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took that image and you put it in your January 30th, 2025 PowerPoint, correct?
I'm pulling up my version of PowerPoint.
Oh, Miku, I would have Sleuthie on in a heartbeat.
Yes, that's correct.
Okay, if we could take that down, I'm going to go to the next example. We could go to Dr. Welcher.
I'm sorry, actually, can we go back to that?
Yes. With
Here, this asshole is doing something that infuriates me again. He knows there's a time limit, so he stalls. You asswipe.
Your Honor, why do we?
Well,
I have limited. Go ahead.
so that particular diagram I did not use. If you notice, the diagram I used has different cars and doesn't have all the writing about the position of things on it.
I am going to now, Your Honor, have to take the time to go to Trooper Paul's report. We have the hard copy of Trooper Paul's.
Could you turn the lights on, please?
May I approach, Your Honor?
Yes.
I'm going
Show
to,
Mr. Brennan.
yes, Mr. Brennan, this is, may I approach you, minutes? Excuse me, Dr. Welcher. You see this first page, do you recognize this as the cover page for the Trooper Paul report that I was referring to? You want to look at the report, sir? I'm not so sure there is a signature on the report.
I don't know if you noticed that. But Alessi was really, really sure to remove that sticker. Because wherever that sticker was or whatever it said, that was the point of impeachment.
Signature block right here. Yes, Trooper Paul, page 16. Yes.
He had identifies it's Trooper Paul's report, then that he had actually
Diagram 1.
noticed it.
If I could, Your Honor, republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from Trooper Paul's report that you then used to put into your January 30th slide?
Reminder here. Unless it doesn't say with the added information or with the added text, he's asking, is this the image that you also used?
No, see all the writing on here, the glass top, all the dimensions here. Here's my January 30th one. None of that stuff's here. There's different, none of this stuff is here.
Isn't it the case that this is cropped more and there's a larger picture of the same image or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image. Can we go, Mr. Wolf, to the January 30th presentation?
Slide 36.
Correct. Where did you get that image from that's in your PowerPoint presentation on the left?
I think it was from the file, a satellite image from the file.
What part of the file, sir?
I actually don't know at this time.
How close is the image on diagram 1, the drone image, to the image that you can't now recall where you got it from for your slide presentation? Are they similar?
So that one has a whole bunch of measurements and ID on it, but the underlying image is very similar. It's probably the same one.
Right. Yes. You're welcome.
Ta-da!
Do you know of any other
What?
place you could have, let's put the presentation back up on the slide presentation. Do you know of any other location other than Trooper Paul's report that you could have got that drone image from?
No, I'm not sure I got it from the report. I recall getting it from the file.
My question is, do you know of any other source other than Trooper Paul's report that you could have gotten that drone image from?
So this image is not in that report.
It's not my
Yes, it is. You asked me anything but the report.
The image, just remove the added text. It is that image, isn't it, Dr.
That
Welcher?
image is not in that report.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay. Did Trooper Paul
Good to have you here,
work
Kelly.
on any
Good to have
drone
you here.
images to
Thank
your
you.
knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone images are from the Massachusetts State Police file, correct?
Give me 1 second.
Sir, let me know you've had a fair opportunity to answer that question.
Yeah, give me a second. Yes, it came in a file called cars-trp.jopal.
Okay, so it came
Let's play that again.
-trp.jopal.
You got it from a file that was named after Trooper Paul.
Okay, so it came from, and that's the report of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder
Yes,
that contains a bunch of things, including the report.
understood.
That image is not in his report.
Can you read the file name again?
The image in itself, without the text, is from Trooper Paul?
You just read.
The folder name
Yes.
is cars-TRP period Joe Paul.
Okay. And did you get the drone image from that file folder?
I did.
Okay. Thank you.
You're welcome.
Now let's go on to the May 26, 2025 PowerPoint that you created. And I'd like to go to slides 25, 26, and 27. Have you discussed with anybody today at all the source of what is depicted up on this slide?
No.
Okay, so let's now go to where did you get you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
25, I believe.
Okay.
Okay, and then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27, looks like it's the same one. You tell me.
Similar.
Similar, okay.
Yeah.
In 27,
Correct.
see the same or similar one there. Okay.
These are all from Google Maps.
Well, my question is, may I approach, Your Honor?
Yes.
Thank you. Let me ask you this so I don't keep going back and forth. Do you have access, sir, to the cars reported Trooper Paul on your computer? Think so?
You remember the name of it?
I don't. We'll do it with a hard copy. Mr. Brenner, I'd like to show you. Thank you. So if I could approach, Your Honor?
Yep.
So you see what I'm pointing to right here, which is page 10 of Trooper Paul's cars report. Do you see that?
Is this the same report dated 1/29/2022?
I believe so, sir. Let me just take a peek. This is, you can just compare, this is the one I have in my hand. Take it and look for any identification it gives you, right? We got the same one.
Yeah, mine's.
Okay,
So that's okay.
okay. So we have that report, and I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation right now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay. Alrighty. Now let's go to your, continuing on the same slide. If Mr. Woke, we could go to slides 22 and 23.
Okay, and this will be the last on this, Mr. Alessi. If you want to get to the autopsy photo, we're wrapping this all up at 4:10.
Okay, Your Honor. You see these photos?
I'm sorry.
You see the photos that are up on that?
I do.
Okay. Do you, in terms of those photos, do you recognize any aspect of those photos?
Yes.
What do you recognize in terms of the person in it?
Oh. You want me to limit it to just these three photos?
Any photo that would be this photo or any photo similar to it. But let's start with just these three.
If I have to limit it to these three, I don't know who that is.
Okay, and if you don't limit it to those three, who would you conclude it is in those photos?
It appears to be Trooper Paul from other photos.
Okay, so you can tell from other photos that this is Trooper Paul in these photos, correct?
I have photos of Trooper Paul in the car. I don't know that someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Okay. Would you have any understanding that there's any other trooper that would be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Inside the vehicle doing what's depicted here.
Someone's inside the vehicle taking the photograph.
What's your best conclusion as to who that is?
Trooper Paul.
Thank you. Your Honor, that is,
Okay, so next topic.
yes,
Go right
thank you.
ahead.
And I just need to reload, if you will, with regard to that topic.
Remember when Judge Bev had the ARCA guys in for 2 days? And they get 10 minutes for this lying son of a bitch. Unicorn 11 with 15 pounds. You may have already said, But what kind of impact do you think that Welcher and Burgess have had on Aperture's credibility? And what do you think the jury thinks to them and their testimony? Oh, Burgess is ruined as an expert. His career is done. Not because of the data, but he lied. He lied on his resume. And he tried to lie about lying on his resume. He's done. His career is shut. This guy, Welcher, through this trial, and probably through all the civil litigations he has done with the insurance companies, will probably, sadly, be more in demand. Now, what does that make with this jury? I don't think Welcher did a bad job per se. He is an absolute professional at being a professional expert. He did, if I'm trying to be unbiased, he did a good job in shifting blame, because he claimed he could not answer correctly on the questions because of the questions, which for me is bullshit. But I don't know how the jury will see it. I don't know. But I do think what might be against him is his aperture. It's hard. But I do believe still, because the state is doing a much better job this time around than in the first trial. I think the risk for Karen is much higher this time around for a conviction of at least one of the charges. And I do believe that is more or less because of her interviews. It's really easy, folks. Don't talk. Shut the fuck up. Because everything you say can and will be used in a court of law. It's that easy. So those interviews, if she gets convicted, I'm blaming the interviews, because that gave the prosecution an enormous amount of ammunition. Enormous amount. Thank you for your question. Thank you so much. And that, folks, gets us to the next spin of the wheel. It is the Wheel of Regrets. Really? Tequila! Where's my tequila? Oh. Tequila! Bucky's. Tequila. Oof. Cheers, folks. And we are very close to the end of the stream, so thank you. Thank you for being here and everything. Cheers. Oh. Oh, yeah. That was interesting. All right, let's get through this.
Woe to slide. You could, Mr. Arnold, you can go to slide, and I think I can do this fairly quickly.
Okay.
If you can go, Mr. Woe, to slide 131 of Dr. Welcher's PowerPoint presentation, and it's now 132. I don't believe that's the right one. It's the,
One before that.
I think yeah, okay. So this is slide 131 from your slide presentation, correct, sir?
Correct.
And if you look to the far right, I'm sorry, Mr. Welcher, go to the other one. Yes, that one, and scroll down so we can see what's in green. For that depiction, that is from Dr. Scorti-Bello's autopsy report, page 3, correct? Is that where you got that from?
It's from the report. Take your word for it on page 3.
So, but it is from Dr. Scorti-Bello's autopsy report, correct?
Correct.
Now, if you could,
This was objected to earlier, and she apparently decided they should have a voir dire on it. But apparently, he read most, if not the entirety, of the good doctor's report.
go to, if we could zoom back out and go to the multicolored image in the center, up at the top. Yep, thank you. If you can go to the very top line, it says autopsy report performed by Irene Scorti-Bello, MD, PhD. If you could scroll back over, date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
Okay, you are all set, Doctor?
Thank you, Ron.
All right. Oh, did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
Keep on 2 minutes. Dr. Welcher, you were shown a photograph of the street of Fairview.
Again, here it's Mr. Brennan with his new hairpiece or spray on hair, or he shaved the tuft of disgraced and put it on his head.
Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report at
It
all.
was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted to be independent in my analysis.
Regarding Dr. Scorti-Bello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a
Let me get you to normal speed. Listen to what the motherfucker is saying here.
conclusions about whether this was caused by a car accident or not? Did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have
I wouldn't take a person's like that opinions. A person like what? Dr. Welcher? A woman? A person with an actual degree? What do you mean, Dr. Welcher, when you're saying I wouldn't take the opinions from a person like that? Do you think she's Jewish? She's Italian, of Italian descent. Or is it because she's a woman? Or is it because she is a medical examiner with decades of experience? Or is it because she refused to come to your conclusion? What in God's green earth made you say,
No, I would want a biomechanical analysis.
Was your opinion her conclusions about whether this was caused by a car accident or not? Did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever
a person like that's opinion? That comment alone over here would get everything you said so far thrown out of court so fast and so hard. You would get lacerations on your arm. You do not make these kinds of comments on fellow professionals. You do not ever say the words, I wouldn't take. Let's listen to it again.
conclusions about whether this was caused by a car accident or not? Did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you
I wouldn't take the opinions of a person like that. That, folks, is bias. He couldn't handle. I don't know why, if it's a woman, if it's an ME, if it is whatever's. You do not say, I would not take an opinion from a person like that. That comment in itself, I can't say it. I wouldn't. To say this is infuriating is understatement. This is so bad. It should get Judge Bev, because if this is how he feels about women, he feels this about you, Judge Bev. Reminder here, Judge Bev, you told him to not look at his report or his computer, and he did so anyway. That's the respect he has for you as a judge. Sadly, this was not in front of the jury. But I can almost guarantee this will be brought to Judge Bev tomorrow morning. Because I don't think many caught this. Now, I posted it on X and I got a bunch of views, but I haven't seen it a lot. So I do believe people tuned out once the actual testimony was done. They didn't tune in to the voir dire. I don't have a benefit of the doubt here. I wouldn't take a person's like this opinion on this. There's no good coming from it. It's either he excludes her because she's a woman, or he excludes her because she didn't get the opinion he needed. Or a third option, he doesn't take the word of medical examiners. Many who has decades of experience, who has bachelor's degrees, because he believes either a woman or an ME is beneath him. This is so bad, folks. This is so bad. Extremely bad. But that, folks, brings us to the end of this stream. Let's just say day 23 might be extremely interesting. Wouldn't it, Mr. Jingles? And I will be here recapping. I will probably do, tomorrow is a half day. They are just doing the morning, so I might start earlier tomorrow, but I will give a heads up. My stream will probably be announced around noon Eastern Standard Time. Probably will start around 3 p.m. on this channel, on X, on Rumble. All right, folks. I'm going to send you off to Valhalla Awaits and his goats. Yes, if you haven't seen it, Valhalla Awaits raises goats. And let's see here. He has new baby goats. One of his goats gave birth the other day, so you get to see actual, just a day-old baby goats. Oh, thank you, Stringer Bell, for $10. Saying, love you, Nick. Thank you. Love you too. And thank you. You know what? As a nightcap, Sambuca! Just for the fun of it. Hello, Mr. Jingles. Hello. Aw, hello. Aw. So, tune in here for Mr. Jingles, for me, for Snark, for not tomorrow, but Friday, for Slightly Bust Friday show. But folks, thank you. Thank you for being here. Have a good one. And I will see you tomorrow, or maybe around 3 p.m. Eastern time. Okay? See ya. Bye-bye. Oh.
Sail the raven waves, brothers. Axes high, shields strong. From distant lands we gather.